Morning members, morning colleagues from the department. Can we get an indication from the colleagues who will be sharing? We're also under load shedding, so some of us are using our phones as well. So just want to assign the sharing rights to colleagues.
Yes, good morning, Mr. Secretary. Mr. Makudu Bete is first chair on the cannabis bill. And you can also maybe allow me sharing rights just in case we lose Mr. Makudu Bete as a result of load shedding during the meeting. But he will lead us. So from cannabis's side, we would like to, and I think, but Mr. Dingane Mgena would be able to confirm whether he also needs sharing rights, and I think he is doing the JMA. Thank you.
Good morning, Chairperson. Advocate Sibele Mecha will be, presenting the presentation through to the portfolio committee, and then I'll probably be piggybacking on his presentation whilst he's busy, presenting to the portfolio committee. Thank you.
Has Advocate Sibele Mecha joined? I can't seem to find him. Colleagues from the TCS, Ms. Andronica, who's sharing from your side?
Morning, colleague. Let me just confirm who would be sharing from our side because we're not all in the same venue. I'll revert to you just now.
Yeah, I'll also make you a co-host in case they're struggling so that you can take over. The thing is, we're under load shedding, colleagues. We won't be able to assist today. So hence, we want to make sure anyone who's here from the teams can assist.
Recording in progress. Recording stopped.
Morning, Mr. Sibele Mecha.
Yeah, morning.
Yes. Who's with you so that we can also give them the sharing rights?
Yeah, you can go to Tabisile Mahlangu. Tabisile Mahlangu, she'll assist me to upload the documents.
Yeah. Done.
Oh, thank you. Thank you.
Colleagues from the TCS? Mr. Jock, Mr. Van Wyk.
Good morning.
Yes, I've made you a co-host, so you'll be sharing from your side. Because we can't assist today, we're also under load shedding. Just trying to give everyone who's with you on the team to assist.
I can definitely share. Do you want me to share the
No,
full app?
not now. You'll hear from the chair. I'm just trying to sort those things out for now. I've given you permission. Who else is with you so that in case you're struggling, they can assist you?
No. I'm alone here, so but it's fine. I can do it.
Okay, thank you.
It's a pleasure.
Thanks, colleagues. I think we're good to go. You will only share when the chair calls upon you. Thank you.
Morning, colleague.
Good morning.
I'm also going to ask the right to share because I will be doing the presentation. Thank you.
Granted, leadership. Already. Thank you.
Thank you, leadership.
Good morning to everybody. You are all welcome.
Good morning, Chair.
Morning, Chair.
Morning, Honorable Breitenbach. You are all welcome
Recording in progress.
to this meeting. We have 3 items today. We will start with the Judicial Matters Amendment Bill, followed by Cannabis, and then Correctional Services Amendment Bill. We should be done by 1 o'clock. So I will appeal to everybody to be extremely focused. This is how we are going to be managing our meetings going forward because we are dealing with more than 2 bills at a time. So we'll in our agenda, we will have more than 2 bills every day in our agenda so that we can push these bills and to meet the Constitutional Court deadlines that have been set for correctional services, for NPA that is still coming, for RICA bill that is still coming. So we are really under a lot of time constraints. But with that said, are there any apologies? On my side, I have one apology from Honorable Masego Jele. She will be landing at about 10 o'clock, then she will join thereafter. Are there any other apologies?
Chair, we've got an apology from Honorable Yako. She's on sick leave for the whole week, Chair.
Yes. Okay. No, we will share a speedy recovery. I'll speak to her after the meeting. Is that all? Let's proceed. Deputy Minister, you are welcome as the leader of the delegation from the department. We're in your hands.
Thanks, Chair. I'm with, I think it's Mr. Advocate Makulubete that will, Advocate Sebelemecha that will, wrong bill. Advocate Sebelemecha who will be presenting on this. But basically, last time we went through the responses to the public submissions. and then an A list was drafted and submitted to the committee with the actual amendments. I understand that we've also submitted I don't know if it's called the B list, but basically the text of the bill with the amendments in that. So I'm not sure how you want to proceed, whether you want to go clause by clause or how you want to do it. But there isn't much complexity in the issues, I don't think. But if you can just give us guidance, Chair, and then I'll hand over to Advocate Sebele Mecha.
Yes, can we do clause by clause so that we know that we are done with the bill once we are through with the clause by clause?
Okay, then I would suggest, Chair, that Advocate Sebele Mecha takes us through the text of the bill with the amendments in it, which I think the members have, but to flight that so he can go through it clause by clause. Because if he goes through the A list, it's very difficult to follow without seeing what's actually happening in the actual bill. Is that okay? Okay, then I'll hand over to Advocate Sebele Mecha. Thanks.
Good morning, Chair and honorable members.
Good morning.
I'll be assisted by Ms. Mahlangu to share the working document, which we have indicated the changes that emanate from the A list. On the long title, there will be some consequential changes in respect of the clauses that are being rejected.
Sorry, Advocate Sebele Mecha, there's a hand. I'm not sure whose hand is that. There was a hand from a certain Samsung. Okay, no, let's proceed.
Yes, I was just trying to explain that on the long title, there will be consequential changes that emanate from some of the clauses that are being changed or rejected altogether. So from on page 5, the first consequential amendment is with regard to the rejection of the clause that deals with the electronic clause 30 that we indicated emanates from the rules board, which indicates the electronic serving of documents. That's the first one, is on page 5, just at the bottom. So that will be removed from the B bill. There it is. Then the other change on the long title will be in the next page 6. There it's the transitional arrangement that will flow from the rejection of the clause that deals with the crime of defamation, that we are to remove that all those pending cases should proceed unless the person, where the person has already pleaded. So the proposal was to reject that clause. Then you can move just below in that page. Remember, Chair, we had proposed that the subsection 4, which talks to the calling of a witness by the court, should be rejected or deleted, and that's where the deletion will come in. So what will then happen is that the next sub-provision, that will be subsection 5, will now become subsection 4. It is just on the next page. Yeah, there the only change will be just the numbering there, just to indicate that it changes from sub 5 to sub 4. Then another change will be on page 8.
Chair, sorry, Advocate Sebele Mecha. Chair, just one clarity. Do you want to pause at the end of each clause, because that's then clause 1 that's been dealt with, as to whether members are happy, or how do you want, or do you want Advocate Sebele Mecha just to run through the whole thing?
No, I think if there is a hand of a clarity, or a member wants to raise something, then they will raise their hand. But in the absence of that, we will continue. We'll just proceed.
Okay, thank you.
You can proceed, Advocate Sibelemecha.
Yeah, thank you, Chair. In clause 3, the change there talks to the issue of the amount, where we had indicated or proposed that instead of having the 1,000 reflected in the Act, we should rather indicate that it's an amount determined by the Chief Master by directive from time to time, so that, because there was a comment that we should increase it to 5,000 rands, but still we thought that every time it changes, we then have to, go to amend the Act. But rather, if it's determined by directive from the master, then that will be much better. Then as well, there was an issue that current or transactional are basically the same type of accounts. And then we should remove the words current or, which we are indicating there. And further than that was to say, then instead of or account, because we need to determine, then we'll say the type of account as directed from time to time by the Chief Master. And we had indicated that this could be anything other than a transactional account, perhaps an investment or so. Then the Chief Master will then issue directives. If I may, then just below that, that is clause 3, basically. Then the next change will be on page 18, which talks to clause 10. Yes, yeah, that's the big. Chair and honorable members will remember that we had proposed that we do away with the criteria for the types of offenses that would not, once a person has paid an admission of guilt fine, would not attract a previous conviction. Then we had then said we may have to, we propose that we do away with C, because the issue of the high volume is a bit difficult for people to understand, and also that poses a low risk of harm and danger to other or the accused should rather be removed, because there is generally a criteria that indicates what type of offenses. So this, we thought the additional wording was not really adding much of value, but complicates the understanding of what types of offenses are we referring to. And that consequentially, by removal of paragraph C, would mean that the current paragraph D will then become paragraph C. That's basically the change on clause 10. And then the next will be on page 22, that talks to clause 11. The chair and honorable members will recall that when we presented the summary of responses, we had indicated that actually section 186 talks more to witnesses in the proceedings. Rather, the appropriate or relevant section would be section 342A, which talks to the issues of delays in court proceedings, as the person to be called or the court manager or the DDG responsible for court administration is not necessarily a witness in the proceedings, but rather in relation to the delays. So the clause 11, the proposal was to reject clause 11 altogether. Then instead of it, we'll have a new clause that will be section 342A, that will be substituting subsection A there. If you may proceed just below for the information below. So the clause that was saying court may subpoena witness will then be deleted. And then if you go below the page, actually to the next page, just to indicate the new clause. Again, just below again. Should be the next page. Yes, it's just there. The subsection 1 currently provides that a court before which criminal proceedings are pending shall investigate any delays in the completion of proceedings which appears to the court to be unreasonable and which could cause substantial prejudice to the prosecution, the accused or his or her a legal advisor, the state or a witness. Then it ends there. Then the proviso that starts from provided, in fact, the semicolon, provided that when the court requires information pertaining to an infrastructure-related or operational matter that arose at the court which falls within the responsibility of the Department of Justice and Constitutional Development, the court manager of that court must be subpoenaed to give evidence for this purpose, and if he or she is unavailable or unable to respond or provide a satisfactory response, the following officials may be subpoenaed. Paragraph A, the provincial head of the province in which the court is situated. Paragraph B, the Deputy Director General responsible for court administration of the Department of Justice and Constitutional Development, or paragraph C, the Director General of the Department of Justice and Constitutional Development. The proviso where I read from provided is exactly as it was under Section 186. We had just put it under subsection 1 as a proviso to deal with the issue or the subpoena with regard to the delays that are caused or occasioned as a result of the issues relating to infrastructure or operational matters that are in respect or related to the Department of Justice. So that's how the clause will now look like. If the next clause will be, under page 35, which deals with clause 30. Then clause 30 is the one that I referred to in respect of the issues about the electronic transmission of documents. This clause emanates from the input that was made by the Rules Board, that actually the clause seems to complicate what is currently existing. So the proposal was therefore to reject it altogether. Then the next change would be on page 36. Because of the change, the rejection of the clause 30, the numbering will then change in respect of the clauses. From there, what was 31 will become 30. What was 32, which appears, will become 31. What was 32, 33 will become 33. These are all on page 36, as you can move. Then on page 37, what was clause 34 will become clause 33. If you may move, please, to page 37. Then, yeah, this just indicates the changes in the clause numbers. Then on page 38, then the transitional provision, which is clause 36, also the proposal was to reject it altogether based on the inputs, the public hearings, as indicated, that to keep the proceedings that are currently running or in progress would be unfair. Rather, we remove it altogether. So that being accepted then changes that clause 37 as well will become the clause 35, because there are two clauses that have been rejected. So that basically talks to the body of the bill. Then in the memo on the objects, We have also reflected those changes. I'm not sure if I should go through the memo, the object, but basically we are doing consequential changes to what has been dealt with in terms of the bill as the changes. Thank you, Chair.
Thank you very much, Advocate Sibile Mecha. Are there any questions, members, comments? I take it that there are no questions. Members are happy with the work done so far. DM, what will be the next stage from here?
Well, Chair, we're in your hands. We'd obviously like to see the bill adopted by the committee as amended, but we're in your hands whether you want to put each clause to the vote, whether you want to approve the bill now. It's in your hands, Chair.
Okay. Members, do we have the problem with the bill as a whole, or do we want to raise a specific, or is there a member who's got a specific problem with a specific clause? Honorable Breitenbach.
Thanks, Chair. We'll preserve our position or whatever.
Okay.
That is what they always do, so that's not unexpected. But I agree, and I'm assuming then that there's no further questions from Honourable Breitenbach on the content.
It's time, Chair, but at least we do something, unlike the Potchefstroom Magistrates Court, which a year later has had absolutely nothing done to it.
Deputy Minister, don't provoke other debates here. And Honorable Breitenbach, let's focus on the bill at hand. I see a hand here. I'm not sure. Is it Honorable Swart?
Morning, Chair. I've been struggling with gadgets. Can you hear me?
Yes, we can hear you.
Yes, thank you. I'm largely covered by the explanations given this morning and the proposed amendments. I just wondered on the issue relating to the subpoenas for the Department of Justice, and we're aware of the background in that regard, but often it is beyond the purvey of the department, and it is actually public works. And I just wondered if the DM could advise me how would it be covered? Obviously, and is it not possible to also include the Department of Public Works, or would that complicate matters? Because as indicated, often those infrastructure challenges lie with public works, and we are subpoenaed, or the department is subpoenaed. Other than that, I'm generally covered by the proposed amendments. Thank you, Chair.
Thank you very much, Deputy Minister.
Chair, thanks, and thanks to Mr. Swart. Look, the magistrates have been issuing subpoenas already in terms of 342 relating to delays in criminal proceedings because of infrastructure, but also other issues such as the CRT machines or the sexual offences cameras not working. They haven't, as I understand, ever issued a subpoena for public works. I think my gut feeling would be it's better to make the DG of the Department of Justice and Constitutional Development responsible for everything, including public works, because that is the department that's responsible for managing the court infrastructure. So that would be my response. And then just to say the other thing is that what the bill does is allow the magistrates, which I understand they're very happy about, to issue subpoenas relating to other courts, civil courts, family courts, etc., which they weren't able to do before. But I don't know, Mr. Swart, I hope that answers it. I just think from accountability point of view, it's better that it's DD Justice who comes and even talks about the infrastructure and what Public Works is doing about it. It's basically for information purposes, and the DG would have to make sure they have all the information, even if they've had to get it from Public Works. Thanks, Chair.
Thank you. Before Mr. Stone, Honorable Swart, are you covered?
Yes, thank you, Chair.
Thank you very much, Mr. Stone.
I just was asking this for in that clause 11, the reference to the provincial head of the province in which the court is situated. Is that clear enough? I mean, I know we have the context that we're talking about managers and so on, but is that really clear enough? And that's just, yeah, I just have a question mark around that.
You were cutting. I'm not sure whether they were able to hear you.
Oh.
Were you able to hear her, Deputy
No,
Minister?
which clause is she referring to?
I think it's clause 11, and it's also around that thing about subpoenaing witnesses, and it's around it's a sub thing of A.
Yeah, I've got it. That's the one we were discussing.
Yeah.
What's the?
It's about being able to subpoena the provincial head of the province in which the court is situated. Now, my question is that specific enough? Is it clear enough? What are we referring to here? For the provincial head of what? That was just my question. And I've just been pedantic. Is the context enough? That was that's the question that I'm raising.
Yeah, it's provincial head of the Department of Justice of that province. Because yeah, I would have thought it's clear enough, but we could include, and I hand over to Advocate Sebele Meche here.
Can we flight it? Let's go back to it.
We could put in its page 23. We could put in provincial head of the Department of Justice of the province in which the court is situated.
I think that will cover.
Yes, if I may. If I may, Chair, I think I would agree so that we just avoid the,
Advocate Sebele Meche, you're not audible to move.
So we'll update the provision in the.
Not much
sorry,
better.
I was saying I do agree that we might need clarity and indicate that is the head of the Department of Justice and Development. So we will then send the updated A list that reflects the change on the clause 11, and that is reflected. Thank you.
Chair, I don't know if everybody heard Advocate Sebele Meche, but my understanding is he was agreeing that we could add provincial head of the Department of Justice and Constitutional Development into the.
Yes, okay. No, we have. Given all that explanation, members, can we take it that we do agree with the bill? We note the reservations of the Democratic Alliance. Will it be possible that by tomorrow, will it be ready by tomorrow so that we can vote on the bill with a report, or do we need extra days?
Advocate Sebele Meche, you'd need to answer that one.
What will from our side will update the A list and send it through. To believe that they will then have to send it to the A B bill, to the A list and the B bill, which incorporates the changes that the portfolio committee has agreed to. and then the B bill then will be ready. Then the portfolio committee could take it from there. So immediately after the meeting, or after this item, actually, I'm going to send the revised A list to the secretary so that the bills office can then attend to the B bill, which they will send to us to proofread, to make sure that all the consequential changes to the long title and the memo are then taken care of. So as soon as we get the B bill, we should be ready, Chair. Thank you.
Advocate Sebelemecha, sorry, you're not answering the chair's question. Can that be done by tomorrow, or do you need more time? I think that's what he was asking.
No, actually, what I was saying was today I'm going to send the A list. If immediately after we finish the item, and if we get the B bill from the bills office done today, then we should be ready by tomorrow.
Can we vote on this bill on Friday? Can we vote on this bill on Friday? So whatever you need to do, but on Friday we need to vote on this bill because it needs to go to the NCOP.
Thanks, Chair.
Thank you very much. Thank you very much. Thank you for the good work. Can we proceed to Cannabis bill?
Chair, sorry, just also before you leave, the issue of the committee report. Presumably, I don't know if you want one, but presumably, and that's drafted not by us, but by the committee section, or by the content advisors. But presumably, you'll also consider that on Friday, so it can be finalized one time.
Yes. I think we will do that on Friday, so that we are done with this bill, unless there's objection from members. No objection? Yes.
Yes, we'll consider that. Just tell him we'll consider that. So he must not expect us to do that. We'll consider it.
Okay. Let's go to the next item. Cannabis bill.
Chair, just from my side, that's to then Advocate Makulubete and Mr. Dupriya. I will be trying to be with you more on the cannabis bill to try and help resolve the issues. But it would be Advocate Makulubete who is presenting.
Okay. So that's fine. Let's proceed.
Thank you very much, DM. Good morning, Honorable Chair and members. In the last occasion, Chair, the committee was engaged in the public hearings after the committee has published the bill once again for the inputs from various role players in relation to specifically the inserted hemp commercialization clause. We have received this the comments, and Chair, I will prefer to share the screen myself. Can I ask someone who's sharing the screen to take it down so that I can do it myself, please? Chair, is the screen visible?
Yes, it is.
Yes, thank you, Chair. These are the comments these are the commentators who have submitted comments in relation to the clause that was clause 11 to 14 of the bill. And Chair, we will recall from the public hearings that there were many oppositions to the introduced commercialization of hemp clause. And as a result, we have gone back to revisit the issue and then When in this presentation, Chair, the proposals will be made to the committee in relation to that when we respond to each one of the submissions that have been made. And Chair, I will not want to go through each one of the submissions made, because in most instances, the response is going to be the same, and I will not want to take much of the committee's time in response to each one of the submissions made. Chair, Afristar, to start with, Chair, they are opposed to the regulation of industrial cannabis or hemp for industrial purposes, because they submit that it creates a licensing permit system that is a barrier to the entry to the rural poor, and continues to leave the existing smallholder cannabis farmers out of potential value chain. Chair, the bill, with the amendments that have been effected thus far, does make a provision for a national legislation to be enacted so as to commercialize cannabis and hemp. So since many role players are opposed to the commercialization provisions being included in the bill, we have reconsidered the position, and we will be proposing to the committee, Chair, that the clauses relating to the commercial activities of cannabis and hemp that are contained in Chapter 2 be removed in their entirety, so that the commercialization aspect of cannabis can be dealt with through the contemplated commercialization legislation. Chair, the further submission is in relation to the distinction between industrial hemp and industrial cannabis and hemp. The submission is that
Advocate Makulubet, so what would make those people to agree? Are they opposed to the principle of commercialization, or are they opposed to commercialization being in this bill? And if commercialization is in another bill, will that make them not to be opposed to it?
The sense, Chair, is that they are opposed to this bill, including the commercialization. And you will see, Chair, when I go through the document, the submission is that the commercialization legislation is the one that should deal with commercial aspects of cannabis, and not this bill, because following the Prince judgment, the Constitutional Court make provisions that the amendment should be effected to the Drugs Act so as to regulate the use of cannabis in their private spaces. So our intention is to say that this bill should be confined to dealing with the Prince judgment in regulating cannabis, and the commercialization aspects of cannabis in their entirety should be dealt with by a separate legislation. So this bill should focus only on the private purposes cannabis, and the separate legislation, which they are in any event proposing that it should be enacted, will be dealing with the commercialization aspect of cannabis. I'm not sure if that answers the Chair's question.
You can proceed.
Thank you.
Sorry, Chair.
Honorable Swart.
Sorry to interrupt. I just wanted to follow on your question, because it doesn't seem to adequately respond to the question. If the rationale for the department is to remove Chapter 2 on the commercialization due to objections that have been lodged, and if those objections would persist even in later legislation, then we as a committee would have to deliberate recommendation or not. I think that this would probably need more persuasive arguments from the department, particularly when it comes to industrial hemp and medicinal usage. But I think if the sole rationale is as a result of public submissions, in which we know have been very vociferous against the whole bill, then it could be problematic. But I think possibly this could be an issue that we'd have to deliberate on. Thank you, Chair.
Thank you, Honorable Swart. Advocate Sibele Mbecha.
Is Chair referring to Mkudubete?
Oh, okay. So sorry. Yes.
Yeah. So, okay. Thank you, Chair.
Sorry. Apologies.
No problem, Chair. Yeah, Chair. That is not the sole rationale for us to have a separate legislation being enacted for commercialization of cannabis. Chair, you'll remember even from the beginning when the bill was introduced, it was our stance to say that this bill is dedicated to deal with the Constitutional Court judgment, and it will not be dealing with all other aspects relating to cannabis. Because in the first instance, the department is not the ideal department to deal with commercialization. One of the other departments is able to do that. Hence, we are saying this bill will focus on the judgment, and the other department will promote legislation that will regulate all other aspects of cannabis in the form of commercialization legislation, which is something that is not within the purview of the Department of Justice. And the Chair, I will also touch on this aspect as I go along in the presentation.
Honorable Swart, maybe let's allow him to proceed, and we can come back to it.
Agreed, Chair. Thanks.
Thank you.
Thank you, Chair. The other aspect that was raised was that the term of industrial cannabis should instead be used in the hemp to describe cannabis. Chair, it is our submissions that as we have even gathered from the public hearings, the term hemp is used synonymously with industrial cannabis. And as a result, either way, we can use either of the two or one of the two terms. However, as we will be proposing, Chair, we will be proposing that this bill will not be dealing with hemp at all. It will deal with the cannabis that has a psychoactive component. And this will be the submissions that, or the proposal that we will be making to the committee.
Sorry, Honorable Deputy Minister. And then how does this bill help with the issues that were raised by the Minister of Agriculture and Rural Development with the new approach?
Yeah, my understanding is that we introduced a bill to comply with the ConCourt judgment. In the hearings, first set of hearings, there was a push for the bill to also deal with the growing of cannabis for commercial purposes. There was then an attempt to provide for that in the last version of the bill that was advertised, but that version then was quite considerably criticized for that in the public participation process. So I'm not too on top of this bill, but I think that Advocate Makulubete will be able to explain further, but there's also other provisions that we think will make life easier for everybody, but we can't, or the difficulty is, it's difficult for the Minister of Justice or for Justice to pass a bill regulating the growing of cannabis for commercial purposes. We tried it and it hasn't really worked, we don't think. Thanks, Chair.
Thank you very much. You can proceed, Mr. Makulubela.
Yes. Thank you, Chair. There's a further submission that in keeping with the World Health Organization's principles, that the bill should not criminalize citizens. Chair, we are in support of this proposal, and we will be making a proposal or proposals to the committee that there should be a reduction of the penalties that were proposed in the initial version of the bill. Chair, you will remember that through the processing of the bill in the committee, there were proposals that were made by the department for the reduction of penalties, as many complaints were raised that they were too steep, and also there should be an avoidance of the incarceration of citizens in relation to cannabis. So what we will be proposing to the committee will be further reduction of the penalties, and the serious offenses that relates to cannabis will be the ones that will see heavier penalties. And this will also be in line with the Prince judgment, the way we will be proposing to the committee in terms of the reduction, and not to criminalize the citizens as it were. Chair, these other submissions relates to the commercialization legislation, which will take care of those aspects. The further submission relates to the way the different forms, or the bill defines the cannabis in different forms, quantities, sizes, level of maturity of the plant, and it distinguishes it from hemp as such. Chair, furthermore, and on the same notion, it is our submissions that the national legislation that we contemplate will be proposed or will be enacted, will be able and will be a suitable legislation to deal with different forms of cannabis, the quantities, the sizes, and all other aspects that relate to cannabis. So the proposals that we will be making, Chair, will also deal with the removal of the quantities as such, because it's one of the aspects that were highly contested by the role players in relation to cannabis, and because they were seen as being too limiting and closing the doors of the citizens in as far as cannabis is concerned. Chair, there's a submission that there is no need to regulate the industry, that is the cannabis industry, aimed at processing and manufacturing, building, and other industrial materials. Chair, it is our submissions that even though we are regulating cannabis, our intention is not to, through this bill, regulate cannabis industry as a whole. However, because cannabis is a substance that has got a THC content, it is something that needs to be regulated somehow, because it has got a narcotic substance, and we as the country are obliged by the United Nations conventions, which we are as a country signatory to regulate the narcotic substances. Chair, the other proposal relates to the promotion of access to the industry, so that the traditional cannabis growing communities in the country who have faced persecution and trial in the past should have some reprieve in terms of the new dispensation that will allow the legalization of cannabis. Our submission is that currently there are permits or licenses that are issued in terms of other legislation, in particular the Medicines Act and the Plant Improvement Act, that currently provides for the issuing of permits. So the bill does not come up with something new in terms of the permits and the licenses. It's something that is regulated in terms of the current existing legislation. And the Chair, you'll recall, we are also making provisions for the expungement of criminal records in certain instances, in as far as possession and cultivation of cannabis is concerned. So this is the expungement clause that has already been in the bill in the first place. Chair, there's a proposal for the fit for purpose approach in as far as industrial and or commercial cannabis is concerned. Indeed, Chair, this is a fair submission, because we are going to be proposing that the hemp commercialization clauses be removed from the bill so that they are dealt with through a commercialization legislation. And there's a proposal that, or submission, that Parliament should consider distinguishing commercial and industrial cannabis, and it is our submission that it is the matter that can be dealt with in the national legislation and not this bill. A further submission, Chair, relates to the support of the bill in principle. This is the submission to the effect that the bill will address the Constitutional Court directive to legalize cannabis and to provide a legal framework for the legal cultivation, sale, and consumption of cannabis and related products. Chair, we note the support. However, we need to highlight that the Constitutional Court did not permit the sale of cannabis, because the court was specific to say that the sale of cannabis amounts to dealing in cannabis, and which is a very serious problem that the country is still faced with. However, we do note the support in terms of what the bill is trying to do. And Chair, the further submission relates to the fast tracking the processing of this bill, because now the time is running out before the next election, and we note this submission, Chair, and it is our view that the Parliament will do its best to ensure that the bill is passed or is processed as soon as possible, and it will ultimately get to a point where the Parliament can reach a certain point in terms of fast-tracking this bill. Chair, these other submissions relate to a different strain of cannabis, which is Delta 8 THC, which is different from Delta THC. These submissions, Chair, do not belong to this bill, and we do not need to include them in the bill because they are a matter for other piece of legislation. And however, I did make a note for the committee members to note in relation to our response. What I can highlight, Chair, is this submission, which is similar to what has been raised by other commentators, to say that commercialization of hemp falls unequivocally outside the purview of the Cannabis for Private Purposes Bill, which is supposedly designed to regulate private use of cannabis. Yes, and then, Chair, it is our submission that the commercialization legislation will indeed deal with this. There are also issues that are raised in this submission relating to the risks and the health concerns. And it is our submissions that legislation will also deal with those aspects. in their entirety and cannot be dealt with in this bill. Chair, the issue of cannabis and alcohol similarly negatively impacting on motor vehicle accidents and in combination have a pronounced effect on accidents. The submission goes further that by extrapolation, this also applies to workplace accidents. Our submissions that there is in the schedule to the bill, we are making proposals for the amendment of the National Road Traffic Act so as to prohibit a person from driving or occupying the driver's seat of a vehicle which is running on a public road whilst the person has blood concentration of prescribed quantities of alcohol, THC, and or a drug with narcotic effect. So this provision is already in the National Road Traffic Act. However, we are introducing the insertion there of THC, that is cannabis. Chair, I have dealt.
You have a machine to test the THC for people?
Chair, there's, in as far as we understand, there is no a machine to test that.
So what is the use?
Well, Chair, once if the bill gets promoted, then the measures will have to be taken to ensure that the facilities are available to do the testing, especially like in the roadblocks. However, if there's no test for that, then this provision will not be given effect to. We have the breathalyzer tests for alcohol quantities, and on a similar vein, Chair, we may have a test a mechanism or a machine for THC. Hence, we have introduced this provision, Chair.
But we never made an inquiry if such technology exists. We just assume that it may exist.
Well, Chair, the engagement, I'm raising this in light of what my colleague has engaged the Department of Transport in relation to this when we introduced this amendment in the bill. An engagement was made by our colleague as to whether there is this, and the indication was that there is none, and we were agreeable to say that we will have this a proposal in the bill, and it will be processed. However, there will have to be measures that are in place to make sure that the instrument is made available to do this testing.
But measures in place, we don't know how much will it cost the taxpayers, whether there is such technology. And I'm aware of a situation where we put things into legislation which might not be implementable.
Well, Chair, I cannot submit further than that, and can I put it in the hands of the committee to say that if the committee decides, then we may not have to proceed with this amendment, and it can be taken out. But the committee can decide if it is necessary to take it out at this stage. Because in any event, once the testing machine become available, then there's still that opportunity for the amendments to be effected so that the testing of THC concentration can be made at a later stage. But I will leave it for the direction of the committee in this regard, as I'm not in a position to take it further than this.
Will members take note of that?
Chair?
Honorable Swart. Honorable Swart.
Chair, me too.
Maybe let's start with Honorable Masako Jele. Honorable Swart is still having connection problems.
And I've also got my hand. Chair.
Honorable Deputy Minister will follow after both of them.
Thank you very much, Chair, and good morning to everybody. Chair, it's just a follow-up on what you were just asking our official. I wanted to find out, Chair, that it is fair for us as a committee to make that determination that if that machine is not available, we must decide that we don't put that in the bill. Whilst the department saw it necessary to put it there, and without making a thorough job in terms of research and making sure that which that it should be used in terms of the bill, when the bill is approved, it is available. So my question is that, Chair, is it fair that we have to make that determination as a committee? It was only that one, Chair. Just a follow-up on that one. Thank you.
Thank you very much. Honorable Swart. I think we can't get hold of Honorable Swart. Honorable Deputy Minister.
Thanks, Chair. Chair, I would have thought that we can't have people driving on our roads that might be under the influence of cannabis. Presumably, they may cause accidents. I think the way around this, so I would suggest to the committee that this provision remains. However, as far as its implementability, what can be done is currently under the short title and commencement, it comes into operation on a date fixed by the President by proclamation in the Gazette, that there's provision for different clauses to come into operation at different times. So we put it in the bill. There is then pressure on whoever it is, transport, to buy devices. I mean, I would imagine currently they would take a blood test and send it off, which is what they do with alcohol. I don't know if there is an equivalent to a breathalyzer for THC. But I would suggest that if there's a concern about its implementability and not holding up the whole bill, that the President is allowed to put different sections of the bill into operation at different times. And this then can be put into operation when that is implementable. But it would seem to me we can't not have a provision that people can't drive under the influence of THC. Thanks, Chair.
Thank you very much, Deputy Minister. I think our concern with Honorable Maseko Jele, the department, you have not even established if such technology exists. Now, in a situation where we say that it must be implemented at a later date, but you find that it is unimplementable because there is no such technology. Now, you have not, I'm talking about you and the department, you have not really provided us with a sense of comfort that this testing, it's in fact that the bill will be implementable because such a testing does exist. So there was no, I mean, I don't think we are opposed or supporting it, but we say, give us evidence that you have done a research, that there is such a testing, there is a machine to do such a testing, or there are ways to ensure that you are able to test a person with THC. That is what we are asking for.
Okay. Thank you, Chair. We have taken note of that, and we will take it further and then conduct that research and engagement, and then come back with the response to the committee at the later stage. And Chair, I must indicate that it is not a new insertion following from the engagement. It has been in there before, but we have, and then we do appreciate the guidance of the chair in relation to this, and we will take it forward. Chair, as I've mentioned, that the other submissions are repetitive, and then they require us to give a repetitive response. I will not bother the committee with those. I will raise this submission in the form of an inquiry as to why is the subject of the use, cultivation, and trade in industrial cannabis included in the cannabis for private purposes. Chair, it's one of the repetitive submissions that I have alluded to say that the bill as it stands does not essentially commercialize cannabis. It was essentially making a provision for other national legislation to be enacted so as to regulate cannabis and hemp for commercial purposes. So it is not the matter of the bill commercializing the cannabis plant in its entirety as seemingly understood by the submission. Chair, there was a submission in relation to the introduction of a clause that will permit legal operation of cannabis clubs, and similar submission is also made in the next submission. And Chair, our submission, our response in relation to this is that the bill as it stands is actually intended to regulate the use of cannabis for personal consumption in private. And it will not be ideal to make provision for social clubs, because it will be contrary to what the bill is intended for, particularly the personal consumption in private. The social clubs will not achieve that intention of the bill in as far as personal consumption is concerned. Chair, the other issue relates to the definition of hemp, which I've alluded to before, and it's also a repetition, and the proposal will be made to the committee for the removal of hemp from the bill, so that the bill can focus only on the psychoactive ingredient of cannabis. Chair, the other comment was in relation to the different strains of cannabis or hemp, particularly the approved cultivar, and also the recognition of certification processes that are recognized globally. We believe, the Chair, and then we submit that this is a matter for national legislation to be to deal with. The issue of the licensing and the permits for any commercial activity, the submission goes to the effect that this permitting system or licensing system are only intended to exclude the ordinary citizens from the benefits of cannabis. Chair, it is our submissions that there already is legislation that regulates the licensing and permitting of cannabis or hemp, and other countries do use the permit systems in relation to cannabis the way our legislation does currently. Chair, there was also a definition in relation to the broader benefits of legalizing cannabis, which we believe it's a matter that can be dealt with in the national legislation, because that will also open opportunities for research, innovation, and job creation. Further, Chair, the proposals were in relation to the exemption of cannabis from the purview of the bill or the provisions of the bill, so that the cannabis can be used for scientific research, for institution of learning, and also for teaching and learning in public and at institutions of learning. Chair, these also are not the matter that can be dealt with in the bill itself, because, as I've mentioned, Chair, it relates to the response to the Constitutional Court judgment in as far as personal or consumption of or use of cannabis in private for private purposes. And Chair, the submission is also made in relation to the use of local hemp for local THC land races, and also the concentration or the percentages of THC concentration in the plant itself. And it is our submission that this is not a bill that can deal with the determination of the THC percentage concentration, and this is a matter for commercialization legislation that can be able to deal with that. Chair, the issue of imprisonment and the steep fines, I did deal with this before. Concern being raised in relation to the imprisonment and also the heavy fines that are imposed by the bill as it currently stands. And as I've mentioned before, Chair, we are going to be making proposals to the committee for the further reductions of the suggested penalties, and the heavier penalties will be proposed to be dedicated for mainly dealing in cannabis and also for engaging a child to deal with cannabis. So it will be our proposal that at least those should carry heavier sentences. Further submission relates to the support of the bill to an extent that it will facilitate the emergence of the hemp industry and provide for a regulated trade in cannabis. But the submission is that the bill will not be able to achieve this. And it is further our further submission and a repeated submission, Chair, that the commercialization legislation will be able to deal with the cannabis and hemp in its entirety. Chair, there was an issue of the bill being unconstitutional, and although it is not highlighted in what respect the bill is unconstitutional, however, we do make submission to this committee that the proposal that we intend to make to the committee, we will ensure that the bill will not be unconstitutional. Chair, there's a proposal that the commercialization should be dealt with by a Department of Trade, Industry and Competition. We are in support of this submission, Chair, and between the Trade and Industry and Competition or Department of Agriculture, Land Reform and Rural Development, either of those could be entrusted with the commercialization of cannabis. Chair, there are other aspects that are raised in these submissions, and in reiteration, they are a matter for incorporation in the commercialization legislation, and also the submission for the limiting of the percentage of hemp It's not a matter for this bill. Chair, there was an issue that has been raised in relation to the destruction of certain hemp plants. Our submission is to the effect that the proposals that we are going to be making will not see to the destruction of cannabis. However, if I may just go back to say that the current bill proposes that a person who is in possession of excessive quantities of cannabis or of a cannabis that is not permitted, those should be destroyed, and the bill was making a provision for that. So this is the opposition to that. However, we are saying the proposals will be made to the committee chair to see to it that there will be no destruction of cannabis. Furthermore, Chair, the issue of the Pondo land, and as a community that has been engaged in the activities relating to cannabis, and the concern is that the bill as it stands will affect negatively these communities, and it is our submissions that even the strains that are, or the land raised strains that are being dealt with by these communities will be properly covered by the commercialization legislation that is contemplated in the bill. Chair, there was a submission also that the comments that the committee has requested from the public, they are not being incorporated. And Chair, the submission is to the effect that when we receive comments, we do evaluate them as the department, and in many instances we do amend the bill in light of the comments that we will have received. So, Chair, essentially we are saying we do evaluate the comments that we are receiving, and it's not the case that we will accept all the comments that will have been made. Chair, the issue of the Drugs Act regulating cannabis, I did mention, Chair, that we are making, or the amendment are being made in the bill in a consequential way to delete the cannabis and its variant from the purview of the Drugs and Drug Trafficking Act, so that the bill as it stands will be able to regulate cannabis in as far as personal consumption is in private is concerned. So essentially, the cannabis will be taken out of the Drugs and Drug Trafficking Act and be dealt with through this bill. And Chair, the further submissions relate to the percentage of THC concentration, and which we submit is a matter that can be dealt with in the commercialization legislation, and also the criminalization of Amampondo cannabis farmers. We are of the view that the bill as it stands is intended to criminalize certain aspects of cannabis in as far as the excessive possession of cannabis or excessive cultivation of cannabis is concerned. And that is how the bill is currently structured. And the intention is not to criminalize the Amampondo cannabis farmers, because there are other legislation, as I've mentioned, Chair, that gives permits and licenses through which these communities are able to conduct their business in as far as cannabis and hemp is concerned. Chair, there's a submission that supports the inclusion of commercial activities in the bill. However, as we've mentioned, we're going to be making proposals to the committee for the removal of the commercialization clauses in the bill. This also deals with the commercialization of cannabis. There were other technical suggestions that were made, and which we will be proposing that they be accepted by the committee. Chair, the extension of the bill to include commercialization is a repetition, and I have dealt with that. There's also a submission that the government does not have a policy in as far as cannabis is concerned, and government should have a coordinated policy. And it is our submissions, Chair, that the formulation of policies and ongoing process through various departments, including trade and industry, and us through this bill. And our bill is mainly focusing on responding to the Constitutional Court judgment in Prince. Chair, the submission is also made in relation to the continued insistence by the bill to separate dagga from hemp. We will be making proposals, Chair, to amend the bill so that it deals with cannabis only, and only the psychoactive component of cannabis. The issue of cultivars is a matter for other national legislation. The submission is made also, Chair, that cannabis or hemp and cannabis must be regulated like other commodity. The end product of the hemp is the one that must be regulated. It is our submissions that cannabis is a substance that has got a narcotic effect, and as a result, it must be regulated as required by the United Nations conventions, which our country is a signatory to. And as I've mentioned before, Chair, we will be making a proposal for the removal of hemp from the purview of this bill. Chair, the last submission also relates to the percentage of THC concentration in the bill, or in relation to cannabis, and we are noting this. However, as I've mentioned, it is not a matter for incorporation in the bill. Chair, this brings me to the conclusion of this presentation of the summary, and I must reiterate, I have noted the comments and concerns that have been raised, and we will take initiative to ensure that they are addressed. To this end, I thank you, Chair and honorable members.
No, thank you very much, Mr. Makulubete. There is Mr. George Swart, who says there is a rapid saliva test that can ascertain if cannabis has been used in the last 4 hours. It does, however, not differentiate between CBD and THC, but useful to know. So I think if you can just do a bit of a research just to give. Thank you very much. Members, any questions or comments? Can you take the slide down? Thank you very much. Any questions or comments? No questions, no comments. Oh, Honorable Masako Jere.
My apology, Chair. I was just trying to open my thing. It's just giving me a problem because I'm walking. As I indicated earlier, it was indicated that I was just traveling this morning. So, Chair, thank you very much, Chairperson. My only comment is that we just want to thank the department for the work that they have done, and also Chair noting that from now onwards, it seems as if, yes, we are going to have two different bills in terms of commercialization. It's a pity that, Chair, when we undergo that process, it won't be in our hands. It will be another committee. We acknowledge that too. And one would really be interested to see if in future, all those things that now the department has decided that they are separating them from this bill and making them or taking them to be included in the bill that will be coming by that whichever department that they have just indicated, Chair. All the concerns, maybe, even if it's not all, but most of the concerns that were raised, if they find expression, so that at least we find a concession, no? Between the department and the presenters. We just appreciate, Chair, that we will go through the bill later and discuss on those issues that maybe they fall on our mandate as per our response to the court judgment, Chair. But in short, Chair, let me say we appreciate the work. I remember the last time it was not good. So they went back and did their work and reconsider some of the things that the presenters were not really happy. We know that maybe this might not be the best, but that work that has been done is acknowledged. And thank you very much, Chair.
Thank you very much. Other members? Can you lower your hand, Honorable Jelle? Thank you. Honorable Breitenbach?
Yes, Chair.
Oh, I thought you wanted to say something.
No, I don't want to say anything at all. Thank you.
Thank you very much. Thank you very much to the department led by the DM for the work done. I think with this work, we would be able to have clear deliberations and conclude on this bill. So when do you think will the bill be ready for us to go through it clause by clause?
Chair, no, I was going to ask where we're going from here, but I think Mr. Makulubete can answer that. There is a draft, but he needs to say when is it in a current state that it can be submitted to the committee. So I'd ask Mr. Makulubete.
Mr. Makulubete?
Yes, thank you, Chair. Yes, Chair, we have a working document that we used in order to formulate the responses for this summary. And I see, Chair, we are in the committee agenda item for next week, and we will be ready to present that working document when the committee sits on this bill next week. We will be ready to do that presentation. Thank you.
Thank you. Is it not possible that you can have that presentation by Friday?
I'm sure. Can I confer with my colleague Chair just 2 minutes? My colleague Mr. Dupree, so that at least we give a coordinated response. But I think it is possible. If I may have 2 minutes, Chair, please.
Please do. Can we have a comfort break and come back at 11:05? Can we come back at 11:05?
Sure, Chair.
Thank you very much. Let's proceed. Mr. Makulubete. Mr. Makulubete. Mr. Dupree.
Just you and me, Chair.
Hey. Deputy Minister John Jeffrey.
Yeah, sorry, I'm here. I'm just trying to get hold of Mr. Makulubete.
Oh,
If you could just
okay.
give me a few minutes. Sorry about this.
While you're waiting, Chair, have a look at your WhatsApp. I've just sent you a message about the study tour.
Okay, sure. No, we'll deal with this after this meeting. Okay, sure.
Chair, I wasn't able to get hold of Mr. Makulubete, but I spoke to Mr. Dupree, who I understand is with him. I see he is online, so if he can just give the response, otherwise I'll have to do it. Chair, do you want me to do the response? Oh no, Mr. Dupree is online now.
Okay.
Thank you, Mr. Chair. Yes, we will be able to submit a working document to you on Friday. We wanted to consult with a few other individuals, but we will be able to present you with a working document. Unfortunately for me and Mr. Makulubete, that means the next 2 nights we won't sleep, but that's no worry of ours. But Chair, I understand the urgency. I understand everything. We do not, and this is the important thing of our department, Mr. Chair. We never want to disappoint our portfolio committee. So if you want a document on Friday, we will give you a document on Friday, which is not necessarily picture perfect, but close to it.
Chair, maybe if I can just add, because I in the discussion I had with Mr. Duprier, I was pushing him. They would prefer to be able to have the document ready for presentation on Tuesday. I was just sort of pushing over the amount of legislation that's coming, but I need to just highlight my role in it, Chair. You are, I think, nicer to the officials than I am, so you may agree to support them. Part of it was also consulting with, I think, some of the parliamentary legal or technical advisors who have also been working on the bill as well. So they would prefer, in fact, Tuesday, but they can do Friday if that's what you want.
Let's do it Tuesday then. Dr. Lutz? Dr. Lutz?
Thank you, Chair. Good morning, Chair. Good morning, members. Chair, if I can ask for the indulgence for Tuesday. Just the reason why I'm asking is we as an office won't have the opportunity to see the document then before it's presented to the committee for us to try and, like Chair always asks, keep the lawyers' negotiations out of the committee and to make sure that we don't have that discussion and debate in the committee process and therefore prolong it. So from our side, Chair, we would beg the committee's indulgence for a presentation on Tuesday to allow us the opportunity to engage with the department's working document before it is presented and to streamline those processes to prevent further hurdles, unnecessary hurdles and discussions going forward. That's just from our side, Chair, because I don't know how we will, if the colleagues from the DOJ will be working on it these next few days when we as an office will have an opportunity to engage with it. So it will be a situation again where we're seeing the document the same time that you as the members are seeing the documents, and we won't have that time to just make sure that our T's and I's are crossed on this side. I'm just weary that we may then have to say to the committee, but we'll in any case have to wait until next Tuesday to comment for us to have that opportunity. That's just a contribution from my side. Thank you, Chair.
Thank you very much. Members, I doubt that you would object if we do it on Tuesday. No objection. Agreed to. So can you work and present the document, work on the document and present it on Tuesday? Hopefully next week we will finish with this bill and it be ready to be debated in the House before we adjourn. Thank you very much. Thank you for the work, good work done. I think it's easier to follow now than I think. Thank you very much. I know that you worked on it throughout the constituency break. Thank you very much for all the good work that and the effort that you put on this particular bill. Thank you very much.
Thank you, Chair. Thank you very much, Chair.
Thank you very much.
Chair, thanks very much. Can myself and the officials from the Department of Justice leave you? As I think we're going to be dealing with the correctional services. Thanks, Chair.
Thank you very much. Moilop. Let's welcome the Department of Correctional Services. I think the Deputy Minister is part of the delegation. Is the Deputy Minister still on? Okay. Who else is part of the Department of Correctional Services? Committee Secretary.
Good morning, Honourable Chair and Honourable members. I do not know who else from Correctional Services is part of the platform. Do you want me to proceed, or do you?
No, please proceed.
Thank you, Honourable Chair. Honourable members and esteemed colleagues, if I may share my screen with regards to the clause by clause, with your permission, Chair.
Okay, thank you. You can proceed. The National Commissioner, sorry, has also joined. You can proceed.
Thank you, Honourable Chair. Is the bill visible?
Yes, it is.
Thank you. All right. With regards to the bill, clause by clause, I'm going to get into it with regards to the preamble. It's to amend the Correctional Services Act of 1998, so as to amend certain definitions to make further provision for the custody of all inmates under conditions of human dignity, and to insert, delete, and amend certain provisions related to the Judicial Inspectorate for Correctional Services, and to make further provision for the compliance management, and to provide for matters connected therewith. Honourable Chair, you will recall that this bill is mainly one of the main objects of this bill is to comply with the Constitutional Court judgment in the Sonke gender justice matter, and also to provide further for matters regarding the independence of JICs, and also the perception of to enhance the perception of correctional services cooperation with JICs, and also the perceived independence of JICs. To proceed with the bill itself, when one looks at the definitions and inserting certain definitions, the first definition to be inserted is the head of the remand detention facility, which means a correctional official designated by the National Commissioner to manage and control a particular remand detention facility. One will recall that there is not such a definition in the Act, although there's a lot of references to the head of the remand detention facility. Then, if we move on to sexual violation, this is hand in glove with the new proposed insertion of section 95D concerning the mandatory reporting obligations of the department to the IJ. Sexual violation has the meaning assigned to it in section 1 of the Criminal Law, Sexual Offences and Related Matters Amendment Act of 2007, Act number 32 of 2007. And also in relation to section 95D, or the new proposed section 95D, the definition of torture has the meaning assigned to it in section 3 of the Prevention of Combating and Torture of Persons Act of 2013, Act number 13 of 2013. Then, if we move on to the proposed amendments to section 30, concerning segregation, it's to basically replace the current section 7 with regards to segregation. It reads at this currently, it reads, I just want to quickly go there. Concerning subsection 7, it currently reads that an inmate who is subjected to segregation may refer the matter to the inspecting judge, who must decide thereon within 72 hours after receipt thereof. The proposed amendment to replace subsection 7 of section 30. Can be found in 7A. An inmate who is subjected to segregation, and this is what is inserted, must be informed of the right to appeal and may refer the matter to the inspecting judge, who must decide thereon within 72 hours after receipt thereof. And then to insert a new paragraph under B, the head of the correctional center or the head of remand detention facility must, upon request, provide all relevant information relating to the matter contemplated in paragraph A to the inspecting judge within 24 hours of receiving the request. Moving on to section 31. Currently, it reads, subsection 5 reads, an inmate who is subjected to such restraints may appeal against the decision to the inspecting judge, who must decide thereon within 72 hours after receipt thereof. The proposal is to replace subsection 5 with subsection 5A and B, which reads, an inmate who is subjected to such restraints must be informed of the right to appeal and may appeal against the decision to the inspecting judge, who must decide thereon within 72 hours after receipt thereof. Inserting subparagraph B or paragraph B, the head of the correctional center or the head of the remand detention facility must, upon request, provide all relevant information relating to the matter contemplated in paragraph A to the inspecting judge within 24 hours of receiving the request. Then if we then move on to section 88 capital A concerning the CEO of JICS, it's proposed that subsection 1, paragraph A, is amended or substituted actually with the following paragraph. Currently, the Act provides the inspecting judge must identify a suitable.
Oh, okay.
Honorable Judge, please proceed.
Thank you, Chair. Currently, section 88A, paragraph or subsection 1, reads, the inspecting judge must identify a suitably qualified and experienced person as chief executive officer who, and then if one looks at paragraph A, is responsible for all administrative, financial, and clerical functions of the Judicial Inspectorate. What we are doing is we are inserting the word and thereafter. Turning to B, and this is one of the sections that was found constitutionally invalid by the Constitutional Court. Currently, it reads, is accountable to the National Commissioner for all monies received by the Judicial Inspectorate. And so we propose that be deleted, that the CEO is not accountable to the National Commissioner for monies received. Then substituting section 2 for the following. Okay, I'm first going to deal with the current version. The person contemplated in subsection 1, that's now the CEO of JICS, must be appointed by the National Commissioner. We are just proposing that National Commissioner is replaced or amended or substituted by the word minister. So that it will read, the person contemplated in subsection 1 must be appointed by the minister. Then moving on to subsection 3, concerning the appointment of the CEO, we propose to insert the words after the appointment, career incidents, so that the subsection will read, the appointment, career incidents, and other conditions of service, including salary and allowances of the Chief Executive Officer, are regulated by the Public Service Act. The reason for inserting the words career incidents is just to bring it in line with the relevant provisions in the Public Service Act concerning the appointment and other career incidents of the CEO or head of department. With regards to subsection 4, currently it reads, any matters relating to misconduct and incapacity of the CEO or Chief Executive Officer must be referred to the National Commissioner by the inspecting judge. It's our submission to propose the amendment of subsection 4 to read any matters relating to misconduct and incapacity of the Chief Executive Officer vests in the inspecting judge, who shall refer his or her decision to the Minister for implementation. Then moving on to section 91 of the Act. Currently, the section 91 of the Act reads as heading expenses of the Judicial Inspectorate, and then it further provides the department is responsible for all expenses of the Judicial Inspectorate. It's our submission to substitute the current section 91 of the Principal Act with the following. The expenses incurred in connection with the exercise of the powers, the carrying out of duties, and the performance of functions of the Judicial Inspectorate, and the remuneration and other conditions of service of members of the Judicial Inspectorate shall be defrayed from monies appropriated by Parliament for this purpose to the departmental vote in terms of the Public Finance Management Act 1999 of 1999, Act number 1 of 1999. Subsection 2, the Chief Executive Officer, in consultation with the inspecting judge, shall prepare and provide National Treasury with the necessary estimate of revenue and expenditure of the Judicial Inspectorate. Subsection 3, the Chief Executive Officer, as the accounting officer of the Judicial Inspectorate, must, subject to the Public Finance Management Act of 1999, and subsection 2, be charged with the responsibility of accounting for state monies received or paid out for on account of the Judicial Inspectorate, and cause the necessary accounting and other records to be kept. This is also one of the sections. Section 91 was the other impugned section, which was found unconstitutional by the Constitutional Court. Then moving on to inserting a new section 95D in the Act, concerning the mandatory reporting obligation of the Department of Department to inspecting judge. It's our submission that this section basically consolidates various provisions in the current Act with regards to the reporting to the inspecting judge, to just make it more user friendly and to centralize the reporting obligations of the department to the IJ, and also adding certain other events to this list in relation and in compliance with international instruments that have been ratified, such as OPCAT and others, and the Mandela Rules. I will proceed to read the proposed section. Mandatory reporting obligations of the department to inspecting judge. Subsection 1, the head of the correctional center or the head of remand detention facility or any official of the department must immediately, after becoming aware, report all instances and notify the inspecting judge of A, any deaths of inmates in correctional centers in terms of section 15.2, B, segregation and extended segregation of inmates in terms of section 30, subsection 6, C, the use of mechanical restraints in terms of section 31, subsection 3D, D, the use of force in correctional centers and remand detention facilities in terms of section 32, subsection 6, E, assault of an inmate by a correctional official, F, assault of a correctional official by an inmate, G, any act constituting torture or cruel, inhumane, or degrading treatment or punishment, H, any sexual violations, I, any hunger strikes, J, any attempted suicides, K, any escape of an inmate, and L, matters related to dishonest practices or corrupt activities in correctional centers or remand detention facilities. Turning to the proposed wording of subsection 2, or subsection 2, the head of the correctional center or the head of the remand detention facility or any official of the department must, within 24 hours after notifying the inspecting judge, in terms of subsection 1, submit a written report to the inspecting judge in the prescribed form and manner on the matters contemplated in subsection 1A to L. The inspecting judge may investigate or instruct the National Commissioner or request any appropriate authority to investigate any matter contemplated in subsection 1. Yes, and then also the amendment of the table of contents to add a reference to the new proposed section 95D regarding the mandatory reporting obligations of the department to the inspecting judge. Honourable Chair, we have dealt with the submissions last week. I'm sure that we have also provided our responses. We submit that if this bill is found in order and voted in the positive, that it then be forwarded through to the NCOP. We leave it then in your hands, Honourable Chair, honourable members. I thank you, and this is our submission. Thank you very much.
Thank you very much, Mr. Van Wyk. Can we go to the head of the detention remand facility? So why should it still be designated by the National Commissioner?
Chair, it's the same. It's the same situation with regards to the head of correctional centre. If one has regard to the definition of the head correctional centre, which in essence talks about the same post or position, safe to say that the one is a correctional centre, the other was a remand detention facility. Currently, the head of correctional centre's definition reads, means a correctional official designated by the National Commissioner to manage and control a particular correctional centre. With regards to that proviso and your question, Honourable Chair, if one has regard to Section 3 of the Correctional Services Act, the National Commissioner has the power to regulate or to appoint officials in certain positions, and hence it relates to the National Commissioner. The head of the remand detention facility, in this regard, we just added it as a definition because there's no proviso for it currently in the current Act, but we submit that it has nothing to do in essence with JICS and its independence, the main object of the bill. We submit. Thank you.
No, thank you. If you are creating a position of a chief executive officer, that person becomes the accounting officer. Is that correct?
That is correct, Honourable Chair.
And the National Commissioner is the accounting officer for the Department of Correctional Services. Is that not correct?
That is correct, Chair.
Why would you create a power for a National Commissioner to appoint a staff for the other accounting officer?
Chair, if your question is in relation to the head of the remand detention facility, the head of remand detention facility is falling under the establishment of correctional services, not under JICS, if that is your reference.
Okay. No, I'm clarified. No, I'm clarified.
Thank you, sir.
Thank you very much. Members, are there any questions? Can you remove the slide so that I can see members? Any questions?
Chair,
Honorable Jelly?
it's just a clarity between those two powers. Is it because they are creating those two posts, that position, which, as you have alluded, two powers are almost on the same level, if for lack of a better word, to replace that. I just want to find out Is this in responding to JICS as independent? Something that I did not get is the JICS now falls under correctional services. It means their independence is taking them totally out. If I understand, it's taking them out totally out of correctional services. There will be no link between the two, Chair. That's the clarity that maybe I've missed or a bit.
Okay, thank you, Mr. Van Wyk.
Thank you, Honourable Chair, and thank you, Honourable Maseko Jele. Yes, with regards to, that's a very good question. With regards to the two powers, if one also has regard that there's a process ongoing, which is quite advanced at this stage, from DPSA and Treasury regarding the establishment of JICS as a government component. That process is at advanced stage. With regards to a JICS bill, which is also at an advanced stage, which basically hinged on final determination by Treasury regarding the finances of JICS, and then obviously regarding the establishment of JICS as a government component. Ultimately, that is the goal, which we are busy with. It's a parallel process, and the intention is at the end of the day that JICS, the references to JICS in terms of its structures, powers, and functions, amongst others, contained in chapters 9 and 10 of the Correctional Services Act, will be repealed by the JICS bill, and then, or the JICS, ultimate JICS Act, and so that JICS will have legislative independence as well as highlighted in the Sonke judgment. That will also then, after JICS has been created as a government component, will comply with the provisions of Section 36 of the Public Finance Management Act, that the CEO of JICS, as it also states in that section of that act, that the head of the department or government component will be the accounting officer. So ultimately, at the end of the day, through establishing JICS as a government component and also enacting, at the end of the day, the JICS bill, it will then create the legislative grounds and the legal capacity for the CEO of JICS to be the accounting officer for JICS, and thereby the current accounting officer responsible for the funds of JICS, the National Commissioner, will then be out of the picture with regards to JICS's funds, and you know, as an accounting officer. So that is ultimately against that background that one should view this. As we've mentioned before, the initial idea quite some time ago, even before the Constitutional Court judgment in 2020, was that ultimately a JICS bill to be enacted as an act will then replace all those provisions regarding JICS. And initially the idea was that it shouldn't be necessary for a correctional services amendment bill. But unfortunately, with regards to the deadline of the Constitutional Court, decision was made by the executive to push this bill through to comply with the Sonke judgment, but also with the proviso that the act only comes into operation by proclamation by President, and thereby also assisting that the processes with regards to establishing JICS as a government component and also furthering the government processes with regards to the JICS bill would then ultimately override all the provisions regarding JICS in the current act as amended. I hope I've dealt with that process. I can just mention that in the meantime, with regards to the independence of JICS, and more specifically the financial independence of JICS, Treasury did ring-fence JICS's funds, although it's going through our departmental vote, more so as a conduit for the funds. DCS has no control over the funds, and also has no control over the functional and operational issues and areas of JICS. So yes, this is the ultimate goal. But for now, to comply with the Constitutional Court judgment before the 3rd of December, we submit that this bill is sufficient, constitutionally sound, as also reiterated or also as opined by the Office of the Chief State Law Advisor. But yes, we are busy with the other processes, and we were also trying to conclude those processes. But we are of the view that it will not be finalized before the deadline of the Constitutional Court of the 3rd of December. I hope that addresses your concern, Honorable Maseko Jele. We submit. Thank you.
Thank you very much. Are you clarified, Honorable Jele? Honorable Jele?
Yes, Chair. I think I'm fine, but I didn't hear that issue of. Yeah, I hear all the explanation,
Thank
but
you.
only on the part, yes, only the part of saying they will be working separately. No, it will be a standalone institution. That's what I wanted to hear.
Okay, so now we are fine.
Yes, Chair.
Honorable Nilbert Rohan?
Thank you very much, Chairperson. Good morning to everyone on the platform. Just for clarity, I wanted to understand something. Eventually, where does JIGS's funding come from? Eventually, once they are independent and if it's no more part of the department, eventually, where will their funds be coming from? Is it going to be coming directly from Treasury? Is it going to be a separate vote? I'm just not clear. Yes, now DTS is a conduit, and it's coming through the Department of Correctional Services, but eventually, where is it envisioned that the funding will be coming from for JIGS? Unpin, Honorable Druffen, please.
Thank you very much. Mr. Van Wyk?
Thank you, Chair. Yes, Honorable Niveau Druchen. Also a very good question. However, it's not within our powers as a department to really comment on that. That is a determination that must be made by Treasury, as they hold the proverbial wallet, and they are the ones who will have to make a determination as to the exact funding route or source at the end of the day of the funding of JIGS. What we do have at this stage is confirmation from the Minister of Finance that in support of JIGS to be established as a government component, that their funding will be channeled through the departmental vote. So that is what we know and what we can say at this stage. And it's basically going to be, it's more a question for Treasury to basically allude to that. Thank you.
Thank you. Are you clear? Are you covered, Honorable Nilbert Rohan?
Yes, Chair, I'm covered. Thank you very much.
Thank you very much. Any further input or questions? Any objection to this bill being adopted? Can I propose that tomorrow we put the bill for adoption and adoption of the report? Honorable Rittenbach and Honorable Engelbrecht, in that order.
Thanks, Chair. Let Honorable Engelbrecht go first, if you don't mind. I may be covered.
Okay, thank you. Honorable Engelbrecht.
Thank you, Mr. Chair. The DA would like to reserve its position on this bill. I just want to add that it is unfortunate that feet were dragged with the jigs bill, resulting in this cut and paste job as a temporary measure to comply to Constitutional Court deadlines. Thank you.
Thank you very much. Honorable Breitenbach.
Thanks, Chair. I'm covered.
Thank you very much. Will the report be ready tomorrow?
Yes, sir. Yes, Chair.
Okay, so we will vote on the bill tomorrow, formally vote on the bill, so that it will go to the programming committee on Thursday. Then they will be able to give us a date for the debate. Now, thank you very much to the Department of Correctional Services, in particular, Mr. Van Wyk, for the work done. Thank you very much. It was nice and clear. So can we see you tomorrow, Mr. Van Wyk?
Yes, thank you, Honorable Chair. Firstly, thank you for the nice words, and yes, we are available tomorrow, yes, definitely. Thank you.
Thank you very much. The National Commissioner, is he still around? Okay.
Chairperson,
National Commissioner?
Honorable Chairperson, good morning. It's Raman Governor from the Office of the National Commissioner. I've been sitting in and listening to the discussions so that I could give the National Commissioner feedback. He's at a JCPS cluster meeting this morning. And it was an urgent meeting called on this morning. And he was also advised that he was not required yet today, therefore he didn't participate in this. So we were advised through the Secretariat that the DG was not required in the same. Thank you, Honorable Chairperson.
Okay, no, thank you very much. Honorable Deputy Minister.
Good morning, Chairperson and honorable members. Well, I joined the meeting closer to the end of the responses by Mr. Van Wyk, because I was in a meeting of the Cabinet Committee. But from my understanding of what has been raised, we are of the view that we've done our bit under difficult circumstances, occasioned, among other things, by the fact that we had to get the concurrence of other departments, in particular Treasury. And they did contribute to the delay that has had to be suffered. But I want to thank the Portfolio Committee for being patient with us, for assisting us even before the bill itself was taken to Cabinet for consideration and approval for tabling in Parliament. We understand that there's been a great deal of impatience for a single bill, that is the JICS bill, to be passed, so that it addresses all the concerns that have been experienced by JICS itself, and also by people who are interested in the independence of JICS as it looks after the interests of the inmates. But we can assure the Portfolio Committee that we will do all we can within the limited amount of time we have to facilitate the fast tracking of the JICS bill, so that the bill can be a fully fledged piece of law that addresses all the issues relating to the functionality of JICS and particularly its independence. But we also of the view that with this amendment bill, we have managed to comply at least with the requirements of the Constitutional Court judgment. Thank you, sir.
Oh, thank you very much, Deputy Minister. No, we do understand that we have always been on the same side, but the delays were beyond your department. But it's important that the National Treasury also should understand that if there are constitutional court deadlines, it affects all of us as government, as the executive, and as parliament. So there shouldn't be a department that will have a luxury when we have to meet a constitutional court deadline. So I think that the 7th Parliament should be much harder on this issue of bills taking forever to, especially those bills that have got constitutional court deadlines, taking forever to come before Parliament. Because even the bill that we have been dealing with, the Cannabis bill, when it was tabled, we were left with only 2 weeks to meet the Concord deadline. Luckily, there was a read-in provision, but that is not the way to work. I think members of the executive, you should be really raising this matter quite sharply in cabinet and within the departments, that this way of working is just not assisting us. It's not assisting us. We do not have the luxury of legislative drafters, enough legislative drafters as Parliament. Now, if the departments delay, at the end of the day, it's Parliament that that has not complied or would not have complied with the Constitutional Court deadlines, and it's just not on. Thank you very much, Deputy Minister. We know that we have fought this battle together, both the ministry and ourselves, in ensuring that we have at least this bill to meet the deadline. Thank you very much. Members, tomorrow is going to be a short day. We would have only the adoption of the report of this Correctional Services Amendment Bill report. We are really trying to push so that either next week, by Friday next week, in fact, they say Friday next week, we should have Parliament, Dr. Lutz, we should have Parliament to brief us on the Mutata matter.
That's an order, Chair. Thank you.
Yes, next week Friday we should have that one. And then Committee Secretary, there is a matter that we have not finalized. We agreed that both the Minister of Finance and the Minister of Justice would appear before the committee in relation to matters that were raised by information regulator. So can you write to them? Let's find a day after Friday that week before we adjourn. We must have both Minister of Justice and Minister of Finance. Honorable Horn.
Yes, thank you, Chair. While we are on the Mutata matter, I believe we should consider as a committee to again engage the Speaker about the Glope matter as well. If news reports is to be believed, the review of the JSC Tribunal's findings by Judge Glope has stalled on the basis that he's of the view that the JSC must pay for the preparation of the record of the tribunal, whilst seemingly the ordinary rule and the rules of the JSC makes it quite clear that whoever wants to make use of the record has to pay for it. Now, the difficulty from where we're sitting is that we, of course, had one meeting where we dealt with this matter. Then it was paused on the basis that Judge Glope announced that he was taking this matter on review and was to interdict Parliament from finalizing it pending the review. And then, if my memory serves me correct, we were informed that the Speaker has reached an informal agreement with Judge Glope that the matter will be paused on the condition that he, in a speedy manner, lodges his review application. And the difficulty now is that we are receiving questions as to why the matter is not finalized. There's nothing that, of course, in the absence of an interdict, prevents Parliament from finalizing the matter. So I would want to request that even if it is just not picking up battles at this stage, but if you on behalf of the committee could maybe just engage with the Speaker in writing as to when this matter is to be dealt with, given the information that seemingly the review has stalled. Thank you, Chair.
Thank you. My only difficulty is just this matter was dealt with by the programming committee, and it took that decision as the programming committee. And we deal with matters that have been referred to us. So I would think that because the Mutata matter has been formally referred to us, and there is no decision that withholds it like the programming committee. That for now, let's focus on the program, on the one that has been referred to us. But I would, when I meet the Speaker, raise the other matter. And but it's important that we finalize this issue as soon as possible before we adjourn. We are left with only 2 weeks. That is next week and the following week, and this term would come to an end. And when we come back, we would be left with 3 bills. 3 bills, yes. We have the divorce bill, and the NPA and the RICA bill. And in addition to that, we would be having the BRRR, and we still have to deal also with the issue of looking at the handover report. We have to be involved as a committee in that handover report. Honorable Breitenbach.
Thanks, Honorable Chair. I'd like to align myself with Mr. Horn's input. I think that not dealing with Judge Glope is bringing the entire administration of justice into disrepute. The matter has been dragging on and on and on, and it would be, in my view, a dereliction of duty of this Parliament if we didn't deal with Mr. Glope before this Parliament comes to an end. So I would urge you to, in fact, take the matter up with the Speaker. Thank you.
No, members, my suggestion is that all the parties that are in this committee are represented in the programming committee, which sits every Thursday. Since it was its decision, I think it would be important that the chief whips that sit in the programming committee raise that matter in the programming committee. Thank you very much. We have come to the end of our meeting. At least we will have time to eat before going to the house. Thank you very much. The meeting is adjourned.
Recording stopped.